The Draft Register of Overseas Entities, Protection and Trusts Amendment Regulations 2025.
I call the Minister to move the motion.
Thank you, Sir Desmond. It is a pleasure to see you in the chair this morning. I beg to move the Draft Register of Overseas Entities, Protection and Trust Amendment Regulations 2025, which were laid before the House on the 6th of December 2024, be approved. This government is committed to increasing transparency of beneficial ownership and combating economic crime. Members are aware that since 2022, the UK has had a public register of beneficial ownership of overseas entities owning property in the UK, known as the Register of Overseas Entities. I'll now refer to that as ROE for convenience. The regulations we are debating today will strengthen the transparency of trust information on the ROE to further improve transparency around the ownership and control of land. By way of background, the ROE was created by the Economic Crime Transparency and Enforcement Act 2022, which I will also now refer to as the 2022 Act. The ROE requires overseas entities owning or buying property in the UK to give information about their beneficial owners and or managing officers to Companies House. The ROE is a key tool in helping to crack down on dirty money in the UK and is crucial in the fight against bad actors who use UK property as a money laundering vehicle. The information available on the ROE has been used by many journalists examining corruption, money laundering and assets held by individuals subject to sanctions. Currently, the ROE collects trust information, but there is no public access to that data other than the name of the trustee. This approach protects the rights to privacy for those who operate those structures for a variety of legitimate reasons. However, the government understands there are concerns around the use of trusts to facilitate economic crime, particularly because their anonymity makes assets easier to hide. These regulations are designed to provide further transparency and prevent potential abuse of trusts while supporting legitimate trust arrangements. The regulations we are debating today are laid under the powers contained in the 22 Act as amended by the Economic Crime and Corporate Transparency Act 2023. The statutory instrument is made up of two measures. The first is that it will enable anyone to apply to access trust information held on the ROE through applications to Companies House. This marks a significant step forward in transparency, empowering the public and civil society to scrutinise trust beneficiaries on the ROE more effectively. Anyone can apply to the Register of Companies for information about a specific trust. Applicants must provide their personal information, the name of the trust related to the relevant protected trust information, and the overseas entity's name and ID. Applicants seeking trust information related to minors or more than one overseas entity in a single application must meet a legitimate interest for the requested disclosures. This ensures that the vulnerable are protected, but critical information is available to those who have a valid need, such as investigative journalists. By requiring this safeguard, the government is striking a fair balance between protecting personal information and delivering on its commitment to greater transparency. So applicants do need to show a legitimate interest. They can't just go on a fishing expedition, but they must show that they're investigating money laundering, tax evasion, terrorist financing or breaching of sanctions, provide a statement that they are requesting the disclosure in order to further that investigation, and provide a statement of how they are planning to use the information disclosed to them. If no such interest can be demonstrated, the registrar may withhold some or all of the information. The registrar will notify the applicant of the decision and will provide reasons. If a legitimate interest can be demonstrated, the registrar will release any unprotected information. The registrar will have the discretion to impose conditions under which the trust information is disclosed, such as restricting its use or indeed its further disclosure. Failure to comply with those conditions will be an offence. The registrar may also refuse an application where that disclosure may prejudice an ongoing criminal investigation or adversely affect national security, or where the trust is a pension scheme. I'll now turn, Sir Desmond, to the second measure in the regulations, which involves provisions for the protection of sensitive information and which will come into force before the disclosure provisions go live. Through these regulations, we are expanding the category of individuals who can apply to the Registrar of Companies House to have their information protected. This ensures that those connected to a trust, such as settlers, trustees and beneficiaries, whose information could be published or disclosed by the registrar under a ROE, can apply to have their details protected from disclosure. For instance, where is the risk of violence or harm? These regulations also expand the grounds on which an application for protection may be made to include the grounds that the individual is under 18 or lacks capacity. The protected provisions will come into force on the 28th of February, and disclosure of trust information provisions will come into force on the 31st of August this year. This will allow sufficient time for those eligible to apply to Companies House for protection. This instrument does not change the fact that an application for protection does not exempt an overseas entity from the requirements of the 22 Act or in general. The required information about the trust must still be supplied to Companies House, and the Registrar will still be able to use their general information sharing power introduced by the 22 Act to share protected information with law enforcement agencies and public authorities for purposes connected to the exercise of their functions. So in conclusion, these regulations further the government's mission to improve transparency of the beneficial ownership of overseas entities investing in the UK, driving confidence in our economy and exposing bad actors who seek to take advantage of legitimate situations. I hope that you will support these regulations, and I commend them to the committee.
The question is that the committee has considered the Draft Register of Overseas Entities, Protection and Trusts Amendment Regulations 2025. Greg Smith.
Thank you, Sir Desmond. A pleasure to serve under your chairmanship. I'm grateful to the Minister for outlining in such detail the provisions of this statutory instrument, which indeed builds upon legislation passed by the previous Conservative government. Therefore, in terms of the broad picture on this, His Majesty's loyal opposition welcomes and supports this statutory instrument and will not be seeking to divide the committee on it later. Essentially, the SI expands the category of individuals who can apply to Companies House to have their information protected under the row, and allows trust information on the row that is currently restricted from public inspection to be accessed by application subject to certain requirements. So, just stressing that His Majesty's loyal opposition does support this SI, I just have two questions for the Minister that I would be grateful for his answers on, either directly this morning or in writing later. Firstly, who makes the assessment on who meets the threshold for being considered at risk of intimidation or violence? Is there a published list of criteria for meeting that threshold? And are there a means of appealing the decision for the applicants? And the second question, once an applicant has been successful in their application to have their information protected, how often do they need to reapply, and how frequently will Companies House review that status?
Minister.
Thank you, Sir Desmond. I'm grateful for the opposition for their support in this matter. I think the Shadow Minister's raised some important questions. I think those are operational matters for the Registrar. I've no doubt there will be criteria. There's certainly going to be criteria available for legitimate interest tests. And we do envisage there will be some kind of informal process for decisions to be challenged. But those, I think, are operational matters for Companies House to decide in due course. But I will write to him with further detail on that. I think in terms of the period for which this information would remain protected, my understanding is that it would remain in situ unless something came to light which suggested that information needed to be questioned. But again, that's more of an operational matter, and again I'll write to him with further detail on that. And if there are no further questions, I will commend these regulations to the House.
The question is that the committee has considered the Draft Register of Overseas Entities, Protection and Trusts Amendment Regulations 2025. As many are of that opinion, say aye. Aye. Of the contrary, no. The ayes have it. The ayes have it. Order. Order.
Committee Room 12.